you. Can you hear me?
Yes.
Yeah. In fact, my slides don't cover everything I was going to say, but maybe at the beginning they might be useful. I want to talk about caste and caste discrimination and legal change in the UK. Thank you very much to the Ambedkar King Study Circle for organising this discussion series so quickly and so efficiently against the backdrop of the Cisco case, and also for inviting me to speak to and offering this opportunity to share and learn and talk with others on this issue. So thank you very much for inviting me. I'm going to give a short overview of caste discrimination in the national laws of diaspora countries as part of the context setting for the UK. That will be very short. And I will also include a little bit of information about the international framework as well. Then I want to talk about the struggle to secure legal protection against caste discrimination in the UK, the problem, what the possible legal solutions are, what successive UK governments have done and why, and then the current state of play, what have we learned so far, and somewhat, as Mina has already covered, what next. At the end, I'm going to say a little bit about the Cisco case and whether that has implications legally for the diaspora and national laws on caste discrimination. Like I say, my slides don't go all the way down, but we'll see how far we get. Caste discrimination in the national laws of diaspora countries. So the first point is that South Asian states have prohibitions, bans on caste discrimination, both in their constitutions and in domestic, i.e. national legislation. The first point here is, of course, the national legal approach to caste discrimination was pioneered by Dr. Ambedkar in India. We obviously, the British use law to manage and to create caste discrimination problems. At the same time, at the same time as purporting to remedy some problems, they also introduced others. So one of the big problems pre-independence was the approach with Queen Victoria's declaration that there would be no interference in religious and cultural matters for Indians, and because caste was grouped as a religious or cultural matter, what that meant was that the British could basically take a hands-off approach and could say, well, this is a cultural matter, this is religion, we don't want to get involved in this, this is not a secular problem. And what's interesting is that in some ways that that argument has resurfaced in the UK in recent years. The national legal approach then pioneered by Ambedkar. What we know about the approach in India is that untouchability was abolished in the constitution, and discrimination on grounds of caste was outlawed in Articles 16 and Articles 15 and 16 of the Constitution, and that this was then operationalised by criminal law. So we've got the Protection of Civil Rights Act and the Atrocities Act as amended primarily. The 2 points there in passing, this was criminal legislation, not civil legislation. with all the implications that that means in terms of standard of proof and so on. India still doesn't have equality, civil equality legislation that deals with caste, although many very good activists and academics have been trying very hard to get to the point where an Equality Act could be adopted, but as we know, that hasn't happened yet. I just want to say something before talking about a few examples outside of South Asia of caste in the national laws of diaspora countries, about the international human rights position. I'm sure most people already know this, but just to sort of clarify, the UN Race Convention, ICERD, International Convention on the Elimination of Racial Discrimination, prohibits discrimination on grounds of race, colour, descent, national or ethnic origin. And since the mid-1990s, but particularly since General Recommendation 29 in 2002, caste has been deemed to be, or caste discrimination, I should say, has been deemed to be a violation of this convention. Interestingly, not under the race or ethnic origin label, because it's not mentioned per se in this convention, but under the label of descent. So caste discrimination is a form of descent-based racial discrimination under the International Race Convention. What that means for countries such as the UK, India, the US, South Africa, and all others, as over 170 states parties to this convention, they are required to introduce legislation or other legal and policy measures to eliminate discrimination based on caste and what is termed analogous systems of inherited status. So for all countries, including the USA, which ratified the convention in 1994, there is this obligation at the international level to introduce protection against caste discrimination if it doesn't already exist. Okay, so moving back to national laws. In terms of diaspora countries, Mauritius has caste as a ground of non-discrimination in its constitution alongside race, separate but alongside race. Ditto Gibraltar and Burkina Faso. What's interesting about Mauritius is that although caste is recognised in its constitution, it remains a taboo issue. So it's recognised, but there is a real stigma about talking about caste and about acknowledging that it actually occurs. So, for example, the 2011 report of the Truth and Justice Commission on the impact of slavery and indentured labour, indentured servitude in Mauritius, caste turned out to be a bit of a sticky topic, a taboo topic. In the 2008 Equal Opportunities Act, caste was included, but Mauritius, certainly at the government level, has insisted that there isn't really any caste discrimination. So in other words, having the word and having the prohibition of caste discrimination in the law doesn't automatically eradicate, as we know, in India nor in diaspora states. It hasn't eradicated the problem. It hasn't eradicated the stigma of talking about the problem. Interestingly, neither South Africa and also not the USA, they don't have caste in their constitutional anti-discrimination provisions. So the UK is the first diaspora country to include the word caste in anti-discrimination legislation. But as yet, it's there in a sort of provisionary fashion, or provisional fashion, and there's no, it's not yet graduated, if you like, to an express prohibition of caste discrimination. So in talking about the UK and the problem of dealing with caste discrimination through legal means, I just want to introduce the UK Anti-Discrimination Framework. In other words, what is the legal architecture in the UK? What is the relevant legal architecture? So for behaviour to be classified as discrimination in legal terms, it has to be because of a trait or a protected characteristic, as it's termed in the legislation, of the victim. This is the same as what in other contexts are termed prohibited grounds of discrimination. So whether we talk about it as a characteristic or a trait or a prohibited ground, it has to be something that pertains to the victim. In the Equality Act, we have 9 grounds or characteristics which include race and religion, and race is defined as including these 4 subsets: colour, national or ethnic origins, and nationality. The second criteria for behaviour or conduct to count as discrimination in legal terms is that it must happen in a field which is regulated by the legislation. So, for example, employment, education, provision of goods, services, premises, and so on. So the important point there is that private sphere relations don't count as a regulated field. When I first started working on issues around caste discrimination in the law in the early 2000s, quite a lot of the issues that came up in interactions with people and listening to people was actually a problem of private sphere discrimination as much as discrimination in regulated fields or the public sphere. And it was important to understand that, unfortunately, social interactions and so on are not regulated. Now, there's as things have developed, that might change. For example, with online dating sites and so on, if that's a service, for example, but that's a side, that's a bit of a side distraction to this talk. But it's just to flag up that things change all the time, certainly from the legal perspective. And the third criteria then is that there has to be prohibited conduct. And so we've got 4 types of prohibited conduct. Before I, actually I want to go back, I think, if I can. Before I go on, I just want to explain what this means then. So we don't have a general prohibition of discrimination in the UK. It's only on these particular grounds. And this means, as Professor Brown explained last week in his talk on Cisco, this means that the person who wishes to bring an action must possess a protected characteristic, must get themselves in the box. If they're not in the box, then they can't avail themselves of the law. Just as an aside, it wasn't always this clear in the UK. Before the Equality Act 2010, we had legislative protection, primary legislation against race discrimination, sex discrimination, and disability discrimination, those 3 things only. And attempts throughout the 1980s and 1990s to add to that list, for example, sexual orientation, discrimination on grounds of sexual orientation, failed repeatedly. So we do now have that protection. It was introduced in 2003 by secondary legislation, but only because the EU required us to do so. Ditto the same for religion and age. So the point there is that irrespective of political flavour, UK governments have been very reluctant to add more grounds of discrimination. We don't have a written constitution, so this is to do with the history of how UK discrimination law or civil liberties law has developed. Okay, so the problem, the legal problem. Mina's already talked about the history of migration and, if you like, the source of caste discrimination. So I won't repeat that, except to make the important point that the South Asian population, quote unquote, in the UK is not homogenous, and that's often a mistake that's made by lawmakers. It's not. This is not a homogenous group. We have had anecdotal and NGO and other evidence of not only the existence of caste as a social phenomenon, but also the existence of discrimination on the basis of caste. That, for most people, is not disputed anymore, although it has been for a long time previously. So just to add to Mina's point there, one of the issues that the UK governments have come up with, and one of the opposition points, is that the evidence that's available isn't good enough. So there's a big question about what counts as good enough evidence. But taking as a premise that there isn't a dispute about the existence of caste as a phenomenon, and there isn't a dispute anymore about the existence of discrimination on the basis of caste. The UK government actually acknowledged this publicly in 2015. There has been, and to some extent there still is, no obvious route to legal redress. So what is the reason for that? Well, I've just mentioned that historically the UK is not keen on adding ever new grounds of discrimination. But the other problem is the invisibility of this form of discrimination, particularly in the early years when your populations are already suffering from racism, and then what we have is what is called in the literature a minority within a minority. So for all kinds of reasons, the problem of caste discrimination was not something that was kind of in the mainstream, including not in the mainstream for the established equality actors, and lots of reasons why people wouldn't want to talk about this. However, in 2000, there was a conference at which Dr. Annapurna talked very clearly about the need for legislative change to cover caste discrimination, and also the fact that this would be opposed by sections of the South Asian community. So the solutions then, given the framework I've described, are either to add caste as a ground of discrimination in its own right, or to rely on judicial interpretation of an existing ground. And this takes us on to the topic that Professor Kevin Brown talked about last week, judicial interpretation of an existing ground where caste isn't actually there. This is one way of getting to the point where this form of discrimination could be regulated. And in fact, as I'll show in a few minutes, that this is the argument that the Conservative governments of David Cameron and Theresa May made when they resisted the requirement to add caste to the Equality Act. If we're relying on judicial interpretation of an existing ground, the only possible place that caste could go is race or religion. There are problems with both of those. Very briefly, that religion only works where it kind of overlaps with an anti-caste religion overlaps with caste identity. Race, we've seen the subcategories, and what that means is that caste has to be brought within one of those subcategories, very similar to the Cisco situation. The Equality Act, when the Labour government announced that it was going to introduce the Equality Act, this was an opportunity for Dalit organisations and activists in the UK to try to get caste added into the new legislation from the start as a trait or as a characteristic. Very briefly, what happened is that following a lot of work by Dalit activists and a lot of lobbying, in April 2010, at the last minute before the Act was adopted, caste was provisionally added to the Equality Act, not as a freestanding characteristic, but as the terminology was, as an aspect of race. In other words, as part of that as part of race, which has those different subcategories. But there was no indication of how this would be done. So should it be added as a fifth subcategory, or should it be added to one of the existing subcategories? That wasn't made clear. And also there was no time frame. So this is the power that Mina has talked about. The government gave future governments a power to add caste at a future date, but with no guidance as to how and no deadline. By 2013, it hadn't been added. The government had chosen not to exercise this power. And actually at that point, the ruled out explicitly adding caste to the legislation. So here we're talking about the Liberal Democrat Conservative coalition government. And 4 reasons were given at that time, and I'm going to talk in a bit more detail about one of them. So the 4 reasons were, number 1, the reluctance to add more categories. Number 2, the argument that existing law was sufficient to cover the problem. Number 3, that the evidence available wasn't strong enough, and that goes back to this problem of not taking evidence seriously unless if it's produced by NGO groups. And although that remains an issue, there is no national study on the scope and extent of caste discrimination. So that is something that needs to be done. And the 4th one was community cohesion. So the government's argument was that, as Mina has sort of hinted, that adding caste to the legislation would damage community cohesion. And it wasn't clear whether they meant cohesion between the South Asian community and the rest of the UK population, or within the South Asian community. It wasn't clear. In 2013, Parliament required caste to be added as an aspect of race, and the government promised that it would consult on how to do this, but for 4 years, no consultation took place. In the meantime, we had the Equality and Human Rights Commission research, which built on research already done, as I say, by activist groups and NGOs, and a small study that had been funded by the government in 2010, which pointed to the likely existence of caste discrimination in the UK. Sorry, now this is where my slides go a bit skew with. That is what I've already covered. I'm sorry about this. They were in a bit of a disarray. What we know is that caste in the UK is not religion specific. It affects Dalits irrespective of religion. The opponents of legislation have argued that the idea of legislation is an attack on an entirely innocent British Hindu community, and that, as Mina said, the idea of the caste system comes from Christian Orientalists. It's a conspiracy against Indic religions. The government has agreed that legal protection against caste discrimination is appropriate, but what it's done is it has said we don't need to add it to the legislation. We don't need to obey this requirement because actually there's now case law that that provides that protection is available against caste discrimination via the protected characteristic of race. And so Mina mentioned the Turkey case. There was a previous case where the argument that caste was an aspect of race failed. It's focused on the concept of ethnic origin. So this is a very different approach to what Professor Brown was talking about last week in terms of the application of the Bostock County Gorish test. If you change the sex, would there still be discrimination? If you change the race of the victim, would there still be discrimination? And if there wouldn't, then the issue is race discrimination. In the UK, it's taken a very different form. In the UK, the effort has been focused on arguing that caste is a form of ethnic origins, because that is really the only category within race that it could fall under. The Turkey case was successful, as Mina referred to. Turkey was awarded significant compensation, although she never actually collected it from the respondents. And the government has relied on this case to argue that it is complying with its obligations under the UN Race Convention to provide legal protection against caste discrimination, because victims can now use what they're calling the case law route. Now, the problem with case law is that case law develops in response to damage or hurt that has already occurred. Whereas if caste is a prohibited ground of discrimination in the legislation from the off, this has a very different legal effect from the get-go. For example, the importance of naming a problem. Mina talks about the unnameable problem. If the word caste is in the law, and if caste is expressly prohibited under the law, then this problem is named. It requires the people Mina described as bystanders, everyone, to know something about this. People that work in big companies, in human resources facilities. The Equality Act would impose obligations under the public sector equality duty in section 149 and the positive action duty under section 158. So by naming caste and identifying caste as a prohibited ground of discrimination, it makes visible something that is otherwise invisible. Now, it can be argued that that can be achieved through case law, but as I've said, case law takes a lot of time to develop. It is, you can't predict how it will go, really, until you have got a body of law which upholds the principle that caste is a form of race discrimination, or until you have a Supreme Court judgment to that effect. There is always the chance that a case might not go in the direction you expect, and that has happened in a recent case where a claimant sought to argue that being low caste, quote unquote, is a form of ethnic origin, and the tribunal, was an employment tribunal case, rejected that and said, well, there's no evidence that's been provided. That case indicates something else I just want to raise in passing, which is the cost of bringing legal claims. If legal aid is not available, which it isn't, if claimants are not supported, it's incredibly difficult to win these claims. So the opposition, back to the opposition now from certain academics and religious leaders and so on, the argument that the very word caste is an insult, that caste discrimination is anti-Hindu, that it's Hindu-phobic, the suggestion that it should be introduced is offensive. Those people are not listening to what is being said, unless their argument is that everyone who alleges that they've been a victim of caste discrimination is lying. their argument doesn't stack up. So, and the argument that it's cheap and easy, and that South Asian shopkeepers will be subjected to, or business owners will be subjected to malicious claims. All this kind of stuff has been argued, that legislation would subject South Asian communities to malicious claims and to racism, as if Dalits are not part of those South Asian communities. It's a very peculiar argument. I'm conscious of the time, so I just want to look at the things I do want to say to sort of end up. I want to mention that caste, if caste is either expressly entered into the Equality Act as a form of race discrimination, or if it becomes so eventually through case law. An interesting aspect here, and Mina was talking about the role of caste, or the appearance of caste in other aspects of life. I've done some work on the role of caste in honour-based violence, honour-based abuse in the UK recently, and race is a ground for hate crime, so race hate crime. If caste is considered part of race, then crimes motivated by caste would be race hate crimes, and that means that honour-based violence, which is not an offence in its own right, but is a term that refers to crimes, to existing crimes which are flagged as being motivated by honour, those could be prosecuted as hate crimes, and that's particularly valuable in relation actually to male victims, because a lot of the research suggests that males are victims where there is, as Mina was talking about, a marriage crossing or a relationship crossing caste borders. So it would be another way of bringing awareness to the sort of widespread nature of the problem of caste discrimination. So I'm just looking to see whether there's anything else I wanted to say at the end. I think with the Cisco case, one of the questions is the approach in the Cisco case transferable? And my point is that the diaspora legal systems are all different. So the US system doesn't work in the same way as the UK system, in the same way that the system in India is not immediately transferable to the UK. So for example, one of the issues when talking about legislation in the UK was that people would have to be identified by caste, and people would have to have caste certificates as in India, which is not the case. It just doesn't work like that in the UK. With the Cisco case, I think the change the race argument is an interesting one, and I need some time to think and to talk to people about whether that argument could be used in the UK. But at the moment, the direction of travel is the focus on trying to persuading courts that caste is a form of ethnic origins and therefore falls within race, unless and until the legislation is amended. I have my own questions about that. I think there is a problem with ethnicizing caste identity, so that elevates Jati identity into kind of a freestanding ethnic identity. That immediately takes us into the problems that Mina was talking about Jati identity and the eradication of caste identity and caste discrimination. The last point I want to say about the government is that it has been very, very muddled. So we have the government at different points saying we don't want to put caste in the legislation because it will entrench an identity which is on the way out. We see no role for caste in the UK. We expect it to disappear, which is not at all the same as some of the opponents of legislation who want to protect their Jati associational organisations. So the government is opposing legislation, but for different reasons to the reasons put forward by some of the civil society actors. I think that the issue needs to be transferred sort of out of being simply seen as a kind of a minority or a community problem. I agree completely with Mina that there needs to be a lot more kind of discussion about the transferability of principles that have already been used in discrimination law vis-a-vis, for example, gender identity, sexual orientation, and that there needs to be a lot more effort to bring in, to educate people who don't already know about this, because as I said at the beginning, the law is very important. It's essential for redress, it's essential for naming, but it's not the silver bullet. And so all the things that Mina said at the end need to be borne in mind. The last point, the historical evidence, absolutely. This argument that caste is a sort of a made-up idea of colonialists. Well, we know what that discussion is, but the amount of work being done now by historians on the way that law was used to create caste distinctions and to operationalise caste discrimination well before the British ever set foot in India is growing. And I think for opponents who are of South Asian origin to sort of argue that isn't the case, it really is an ethical issue, as Mina said. Okay, I've just looked at the time, I'm going to stop there. I'm sorry about the slides, but it kind of ran out. I don't know what comes next because I haven't got them printed out and I can't see them on the screen. So apologies for the slides, but I hope that was useful to get some questions going. Thank you.